lightning, as African wisdom decrees, does not strike the same tree twice. But science disagrees, and so does history.
The International Criminal Court could probe the spate of abductions happening in the country if a petition by 2 lobby groups to Kenya's Attorney General sails through.
Kenya now finds itself at a crossroads. The recent wave of abductions and disappearances targeting young activists has alarmed many. Frustrated by the lack of justice, some Kenyans have turned to the International Criminal Court, ICC, urging it to intervene. But before we entertain this path, history compels us to pause. The last time Kenya was entangled with the ICC, the court left battered, humbled, whipped like a stray mongrel, as some might put it. The process was messy, political, and, ultimately, futile. Take a moment to rewind to the early days of William Ruto's case at The Hague. Behind closed doors, then Chief Prosecutor Luis Moreno Ocampo made a bold and unprecedented move. He asked the judges to order Ruto's arrest right there in the courtroom, in his very presence. Of all the 6 post-election violence suspects, Ocampo considered Ruto to be the most dangerous. Why? Ocampo later revealed his reasoning in his book, War and Justice in the 21st Century, a case study on the International Criminal Court and its interaction with the war on terror. He alleged that Ruto was threatening witnesses.
Good morning again.
But the ICC judges did not react as he had hoped. Instead, they demanded that Ocampo disclose the sources of these allegations to Ruto's legal team. A tense moment followed. Seated across the courtroom were 3 formidable defense lawyers, Kioko Kilukumi, David Hooper, and Kithure Kindiki, the man who is now Kenya's deputy president. Ocampo hesitated. He knew that handing over those sources would endanger them, and so he backed down. That moment symbolized the ICC's broader struggle in Kenya: strong suspicions, weak enforcement, and an eventual collapse of the cases.
The International Criminal Court could probe the spate of abductions happening in the country.
Now, with fresh calls to bring the ICC back, one must ask, can history repeat itself? Or will the court, once burned, be twice shy?
Mr. William Ruto.
When the ICC pretrial chamber rejected the prosecutor's urgent request for Ruto's arrest, it was a blow to the prosecution. But even in its reluctance, the court made one thing clear: threats to witnesses would not be tolerated.
Good morning again.
In an open court session, Judge Ekaterina Trendafilova took a moment to address the people of Kenya directly. Her message was stern. The bench would like to address the citizens of Kenya to respect the life, security, and property of witnesses and victims of the 2 Kenya cases. She reminded Kenyans that those who testified at The Hague were fulfilling their civil duty and should never have to pay for it with their safety. But behind the scenes, the reality was far from ideal. Had the judges granted the prosecutor's request for Ruto's arrest, he could have been detained on the spot, prevented from leaving the courtroom. That moment never came. Meanwhile, the prosecution had taken extensive measures to shield witnesses from harm. Their approach mirrored the strategy used in Darfur, where state officials were deeply entangled in the very crimes being investigated. Conducting investigations inside. Kenya was deemed too risky. Instead, prosecution teams operated from outside the country, piecing together their case from afar. Over time, ICC lawyers undertook 92 missions across 16 countries, tracking down testimony and safeguarding those willing to speak. Yet, despite these efforts, troubling reports of witness intimidation kept surfacing. The prosecutors turned to the Victim and Witness Unit, a body under the ICC registry, urging them to relocate witnesses under threat. But bureaucracy proved to be an adversary of justice. The process was slow, tangled in red tape, and prosecutors had zero authority to make the final call on who got protection. The defence, led by some of Kenya's sharpest legal minds, played along with the ICC's security concerns, but on their terms. They told the court they had no objections to the prosecution's plan to reveal the identities of protected witnesses just 60 days before trial. As for witnesses without ICC protection but deemed at risk, their names would be disclosed 30 days before trial. On paper, the arrangement seemed fair. The legal system appeared to be working. But in reality, it was a dangerous game of shadows, one where names were whispered, lives were threatened, and justice remained uncertain. And if history is anything to go by, Kenya should think twice before knocking on the ICC's door once again.
Mr. William Samuel Ruto.
The case against William Ruto didn't just collapse. It unravelled under the weight of what one ICC judge described as intolerable levels of witness interference and political meddling. The court's failure to bring justice was compounded by the shocking scale of witness tampering that would later come to light.
Kenyan lawyer Paul Gicheru on Monday surrendered to the International Criminal Court ICC following a warrant of arrest issued against him in March 2015 for what they court termed interference with witnesses. So according to a statement by the Hague-based court, Gicheru surrendered to the Dutch authorities after a 5-year search. Hassan Mugambi has more.
In March 2015, arrest warrants were issued for several individuals connected to the case. Paul Gicheru, Philip Bett, and Walter Barasa were named. But the most chilling part of the story was the fate of Meshach Yebe. His warrant of arrest was withdrawn after prosecutors confirmed he had been murdered. His body was found discarded in a park, a grim reminder of the high stakes in this case. Fast forward to November 2022, and Paul Gicheru, a man with deep ties to Ruto from their school days at Kapsabet High, finally surrendered to the ICC. He had long avoided extradition, using legal maneuvers to delay his day of reckoning. But when his trial began, the charges were clear. Between April 2013 and May 2014, Gicheru had offered several prosecution witnesses a total of 17 million Kenya shillings to withdraw or change their testimony. Yet, despite these vast sums, the manipulation went further. Gicheru allegedly paid out 2.5 million Kenya shillings and resorted to threats to ensure compliance. One witness, so vital to the case, was never brought to court, not because of any legal complication, but because he was dead. The prosecution laid out the details of the conspiracy. Gicheru, alongside Silas Simatwo, a close ally of Ruto and now Digital Health Agency chairman, and Isaac Mayo, was said to have managed the operation to corrupt witnesses. Meanwhile, Yebe, Bet and Barasa acted as the intermediaries, scouring for potential witnesses to recruit and bribe. But in a shocking twist, Gicheru and his defense team refused to call any witnesses of their own. Instead, they questioned the credibility of the prosecution's entire case. The trial reached its conclusion, but as the court awaited a verdict, Gicheru's story came to an end. In September 2022, he passed away, and by October 14, 2022, Trial Chamber III was forced to terminate proceedings against him because, as the ICC noted, it does not try dead men. And so the curtain fell on one of the most complex and tragic chapters in Kenya's history with the ICC, one that leaves more questions than answers. That's all for today, folks. But before you go, take a moment to reflect on the weight of what we've discussed. The choices we make today shape the future of our nation. If you believe in the power of informed conversation and accountability, like this video, subscribe to Lifelens TV and share it with someone who needs to hear this. Your voice matters. Your opinion shapes the narrative. And together, we can make a difference. Let's keep this conversation going. Drop your thoughts in the comments below and I'll see you in the next video. Stay woke, stay engaged, and remember, Kenya can't afford another mistake like this. Until next time, keep your lens focused on the truth.